Welcome to First Thursday, the monthly podcast from Labor Relations Information System. My name is Rick Poulson, and I'll be your host for the next hour or so as we discuss recent developments in the world of public safety labor relations. This month, we're going to talk about a couple of bargaining cases, and we're also going to talk about a couple of other cases in which correctional officers raised some unique claims against their employers. All of these cases, by the way, are things that we talk about in our public safety labor newsletter. If you don't subscribe to that, head to LRIS's website and sign up. If you're interested, by the way, in collective bargaining or an interest arbitration, which we're going to talk about on the podcast as well, and if you like LRIS seminars or if you've never attended one and think you might like one, we're going to be spending 2.5 days talking about collective bargaining, interest arbitration, all of that good stuff at our collective bargaining for public safety employees seminar from October 25th or 23rd to 25th at the Horseshoe and Paris casinos in Las Vegas. It's a great place. We're going to talk about the entire bargaining process from prep to what happens at the table, to political action, to the ratification process, to dispute resolution, including interest arbitration. Lots of interesting things. We're going to hear from practitioners, including myself, who actually bargain at the table about their experiences. We're also going to hear from, Will Aitchison, LRIS's founder. And so fans of the podcast, if you want to go see Will in person, you can see him in Vegas this October. Today, we're going to talk to another of our favorite LRIS presenters, and that's Tom Gribbin. Tom is a union side labor lawyer. He's a partner at the Philadelphia law firm of Willig, Williams, and Davidson. Good firm, I hear. Yes. Tom spent his entire career representing public safety unions, and he has a particular expertise in really all aspects of representing correctional officers and also in representing police in high-profile, kind of high-stakes discipline cases. In fact, Tom is going to be one of our featured speakers at LRIS's Public Safety Discipline Seminar that we have coming up in November in Las Vegas, and we're going to talk about the entire discipline process and, hear from, I think some of the best lawyers in the country at this stuff, including Tom. And so if you're interested in either of those seminars, just go to lris.com/seminars. We'd love to see you there. Okay. Well, Tom, I made you sound good. Hi, welcome to the show.
Thank you, Rick. I should hire you to do some PR work for me.
I should be your hype man.
I appreciate it.
Well, you are one of our favorite speakers. You always have good stories to tell, because you get the most interesting cases, don't you?
I have found that there is nothing more that a room full of law enforcement officers like to hear than stories about how other law enforcement officers, let's just say, may have screwed up or allegedly screwed up.
Yeah, no, for sure. There's always interesting things to think about. We do have some interesting cases to talk to you about today. But before we do that, let's talk a little bit about you and your background, right? We know that you're a speaker at LRIS conferences. We know you're a lawyer in Philadelphia. What we always interests me with the guests that we have on the show is what brought you to this very specific location, in the practice of law representing public safety unions. So how was it that you wound up, going to law school in the first place?
So as many people in our firm know, Rick, I am a born and bred Pittsburgher, very proud of it. But I met my South Jersey wife and made my way out to Philadelphia years ago to start my legal career. And I knew from a very early age, being a product of trade unions, that the work of unions, the benefits that they provided to my family, was something that interested me, something that I wanted to do in a legal capacity. And so I think I always knew I wanted to represent unions, but didn't know exactly how to do that. And when I came to Philadelphia, initially I didn't start doing union representation, but did get a job with another labor firm here in Philadelphia that hired me specifically to work on matters for Philadelphia correctional officers, mainly discipline cases. And that initial exposure was honestly, which formed my passion. And I would say what's been a crusade throughout my career to improve the lives and working conditions of correctional officers. I routinely say that correctional officers are a group of law enforcement officers who have consistently been marginalized. It's a very, very tough job, and staffing levels throughout the country are critically low. And so the
Yeah.
clients that we work with that represent correctional officers, we're always looking for ways to improve benefits, because you're never going to make the job of being a correctional officer better, but you can compensate them better and you can provide them with better benefits. And that's what we try to do.
Yeah. I mean, it's a tough job, and what I get, from having the privilege of working with COs as well, is like they're the forgotten. There's like three legs to the stool, in public safety stuff. Police, fire, corrections, I think, and in fire include EMS and all. But there's no like Chicago CO TV show on CBS. You know what I mean? Like, so the police and fire get all the attention, and a lot of times corrections unions just the officers doing the work just they don't get enough respect for how hard that job is and how important it is. And it's tough, man. That's tough stuff. And so it must be gratifying to get to work with unions to try to make it a little better, at least, right?
We try to, and you hit the nail on the head. The word really is respect.
Yeah.
They want respect from their employers for the work that they're providing, to the community for the service that they're providing, but they want to be seen as, rightly so, as law enforcement officers.
Yeah.
They're an important part of, like you said, the legs of law enforcement in any municipality or large city.
Yeah, it's definitely a challenge. It's always been a challenge, right? But things got really challenging a few years ago. We're in the midst of like this national recruiting and retention crisis in public safety. And I'm sure you've been experiencing that with the clients that you work with, without getting too much into specific clients, but, have you experienced some of the recruiting and retention challenges, and what, have there been any approaches, that have proven fruitful to at least make it a little bit better for these groups?
Yes, you're right. It is a nationwide problem. It's not limited to any one region. Recruitment issues in any aspect of law enforcement are difficult right now, but especially in corrections. Some of the clients that we've represented, I know that we have seen, and I've shown in interest arbitration or contract negotiations, a 48 to 49% decline in the staffing levels of some of these units.
Yeah.
And so these are major problems that need to be addressed, and we try to come up with ways in which to do that. Some of our clients and some of the municipalities have removed some residency requirements in order to expand the field by which they can look to hire correctional officers. And really, it comes down to compensating correctional officers and really showing that you try to almost purchase the help by raising the wages.
Yeah. Yeah. And that gets to the respect issue. I mean, compensation, look, people work for money, work for a lot of reasons, especially people in public safety. There's other, ways to feel fulfilled. But money's a good start with corrections to try to incentivize people. But then there's just, these issues of leave, right? Scheduling changes, improve family benefits, daycare issues, a lot of things that you may not initially think of. Residency, you mentioned. I'll never understand why you need a residency requirement for any profession, right? But there's lots of ways that employers, I think, are trying to actually, to recruit and retain people they have. But yeah, so it is a really, tough time in public safety for recruiting and retention. And it's not all the union side. I mean, the management folks I think are struggling, with that. And I think a lot of them are trying to do the right thing. I mean, have you had, has that been your experience out there in the field, that there's been a shared desire to address some of these concerns on the management side?
It has been, and I should say, luckily so, that we've had some management really look towards coming up with creative solutions. And I like to think that I can be part of that as well, because in the other half of my life, I'm an elected official in my hometown in South Jersey, and I have been now for 14 years. Uh,
Ah, so your
and
labor and management.
labor and management, I like to think I have a unique perspective, especially even when giving these presentations at LRIS, but especially when I'm doing contract negotiations on behalf of my clients. I can honestly say to management that I understand some of the challenges that they have, especially political challenges that they have. Right now, I'm engaged in contract negotiations with our own municipal police force. I'll be going tonight to our third round of negotiations. So and through that,
Give him a raise, Tom. Give him a big raise, Tom.
we're trying to. I think they'll be very happy. I hope they will be. But it has been fulfilling to be able to be on both sides of the issues and
Yeah.
work towards solutions. And I think that is really where both sides need to be, especially in these trying times with staffing issues and recruitment issues, is that both parties have to be engaged in working towards solutions. But that's not always the case.
No.
Personalities get in the way, politics get in the way, and we've
We're
seen
going to
that.
talk about one of those
We'll
cases,
talk about that.
actually. Oh,
Yeah.
see, we'll hold that thought. We like to talk about holding hands and kumbaya and all that good stuff. And the people that subscribe to LRIS, buy into that. I think it's more effective for everybody in the long run, but it doesn't mean that we don't fight it out from time to time. So let's hold that thought. And I want to ask you about another area of your practice that is interesting and where I think you really distinguished yourself, and that's in discipline cases, in employee discipline cases. And I know you a lot of police discipline cases. Um, you said you're an elected official, right? And we know that the politics and public relations and media and all that stuff can be an issue with high profile police discipline cases. Can you talk a little bit about that? I mean, the challenges that you've faced, without getting too specific about cases, but experiences you've had in representing police officers who've been terminated, you know, in cases that are high profile, and some of the ways that um, employers maybe don't respond the right way.
Sure. And that has become one of the primary focuses of my practice is the representation of police officers in discipline cases. And it's rewarding and fulfilling. I enjoy the work that we do. But as you said, if an officer has done something and I see it on the news, there's a really good chance that that file is going to be on my desk really quickly.
Yeah.
And what I've learned in representing police officers in, as you say, these more high profile discipline cases, and honestly, it doesn't have to be a high profile case. In all cases in which anyone is disciplined, what I found is that, and it's not, I'm sure, limited to police officers, is that people genuinely care about the work that they do. And that's important. And it's important for me in advocating on behalf of that police officer who really wants to get back on and do the job that has been their life's passion.
Yeah.
What I find, though, in a lot of these cases, especially those that make the news, is that sometimes management is making that decision not with, maybe not taking the same steps they would in all discipline cases, evaluating the contract, evaluating steps of just cause. And sometimes they're put under pressure, political pressure, or just the nature and circumstances of what has happened to immediately discipline that officer. And we've seen it in large cities and small municipalities that the knee-jerk reaction is to just terminate the officer.
Yeah.
And that usually leads to many due process violations. And a large part of my representation is to point out where management has failed in that regard.
And you win a lot of cases on due process.
We do. We win a lot of cases on due process issues. But if I guess advice to give to management is to maybe take a different approach. It's hard to stand up to that political pressure. I know, as an elected official, I know that. But if you take a different approach and treat each case the same, as difficult as that may be, in the long run, it may be more beneficial to them. But you may find that discharge might not have been the most appropriate penalty.
Or if you're going to fire some, look, I mean, Will Aitchison was a guest on the show, his final show. He was, I got to interview him, and we talked about, when he started LRIS, and it was due process, procedural issues related to police. It was a police case where there was a complete and utter absence of due process that caused Will to actually start LRIS, right? To say, we have these rules out there and no one seems to know what they are, but they're really important. And, that's at the root of this. And, we're going to talk about it in November. And, we want good investigations because you want good discipline. If somebody screwed up, they should be disciplined, and that discipline shouldn't be overturned. If there's a situation where you win a case in arbitration, very likely, you have situations where the employer just makes a terrible decision, but there's cases where maybe there was, or there might have been cause, but the employer just, for whatever reason, didn't follow the rules. And, that's tough, because I think everybody wants, on both sides, you want the good employees to be treated well, and the ones that don't deserve to be there shouldn't be there. And so part of what I try to do with my clients is counsel them to try to follow the rules. And I know there's plenty of good employee listeners and folks listening to the podcast that counsel their clients to do the same, but it's really hard, man. When you're it's the lead story on the 6 o'clock news and you're a mayor, there's that urge to throw some red meat out and get the pressure off. But boy, you turn somebody's life upside down in the meantime. It's tough. At least you get to provide some justice that's got to feel good. And you have a situation like that, and you give somebody their career back, or to be a part of that process anyway. It must be a good feeling. It is.
It's definitely has been rewarding. It's been challenging, as you said, at times too, because not, as you say, not every case or not every grievance deserves that opportunity, but you want to fight for the ones that you truly believe should definitely get their jobs back.
For sure. All right, let's talk a little bit let's get to some cases. We talk about cases on the podcast every month. And I wanted to talk about some bargaining cases. And one of my favorite cases that we reported out over the last few months comes out of Berks County in Pennsylvania, right? Pretty decent sized county, about 500,000 folks live in Berks County, and it's a corrections case, and it's an appeal to an interest arbitration award, right? So in Pennsylvania, for correctional officers, unresolved negotiations can be submitted to final and binding interest arbitration. And the case we're going to talk about is County of Berks versus Teamsters Local 429. It's a Pennsylvania Commonwealth Court decision. We reported this out a few months back in our public safety newsletter. And Tom, you know a little bit about this case, don't you?
I would say that I know a little bit about this case. This was my case. From interest arbitration, I should say from bargaining to interest arbitration, to the Berks County Court of Common Pleas, to the Commonwealth Court of Pennsylvania.
Oh, and of course, we wouldn't be talking to you about the case if you lost. So we're going to talk about the case that you won. And so let me review the case a little bit, and then I want to get your take on what was really going on here. Like, that's what I like about finding the backstory in some of these places. So, for the listeners, Pennsylvania has a county kind of jail system. This was the county jail in Berks County, pretty big facility, represented by the Teamsters 429, real good union. We've got a group of correctional officers and I think some maintenance folks in the group. Contract expires at the end of 2019. Parties are in bargaining. They're unable to settle the contract, right? And we're pre-COVID, right? We're in 19 bargaining the contract. They get to impasse and they submit their dispute to binding interest arbitration. And in this particular instance, it's going to be a 3-member arbitration panel. You have a union representative, a management representative, and then a neutral arbitrator. What else happened, right? At the end of 2019, we're in the interest arbitration process. 2020 happens. And in the beginning of 2020, you all may recall, we had a little thing called COVID that happened. And so the COVID pandemic begins, and the federal government responded, all right, in a number of different ways. And one of the things that the federal government did, was pass the Families First Coronavirus Relief Act, right? FCRA, we call it. And gosh, it seems so long ago, right? But FCRA was passed really quickly. And it became effective in April of 2020, and it was effective through the end of 2020. And for listeners who may not remember, what FCRA basically did is it gave you 80 hours of paid sick leave related to COVID. And you didn't necessarily have to be sick. You could be in quarantine or something like that. But and it applied virtually across the board, across the board. But it required employers to give people 80 hours of sick leave in 2020. And the idea behind that was, hey, if you have the sniffles, it's probably not a good idea to come to work, right? So that you don't get everyone else sick, which is still a good idea, by the way. Employers, don't forget that. But FCRA applied almost everywhere, but there were some exceptions, right? And one of the exceptions under FCRA was that an employer didn't have to provide this 80 hours of extra paid sick leave to emergency responders. That's the language that the statute used. And different employers took different approaches, and I certainly bumped up against this in my practice. I know, Tom, you did, as well. But in this particular case, in 2020, we have a big issue with correctional officers missing time, not being allowed to go to work, right? Due to COVID. And the union asked the county to provide them with FCRA benefits. Is that right, Tom?
Yes. So as you said, this was at a time where this was all so new to us. And the federal government rolls out FCRA, and we have correctional officers who are sick, or who, like everybody else in the country, might have had their kids home because schools were shuttered and they were trying to figure out daycare, or their spouse may have been sick and they needed to care for the spouse and the family. And so you have correctional officers, like everybody else, dealing with these issues. I will say, maybe not like everybody else. Correctional officers and any of our law enforcement officers know they didn't have the option of appearing to work virtually. So
No.
they're showing
You
up.
couldn't negotiate that into a contract, Tom. Maybe you're not one of the leading lawyers in the field. We need virtual correctional officer work, I think. It's a good. No, what a terrible, our clients are working, right? All the listeners to this podcast, we're out there working. And which is not to say that people who are working from home weren't working, but you get the point. People are out there in the field, and especially in corrections. You're locked in a facility. My goodness. What a crazy situation that folks were facing. What was it like in Berks County?
In Berks County, and I don't think anyone that might be from the eastern part of this state, I don't think I'm shocking anybody when I say that the relationship between management and the union here has, let's just say, not always been good. And so we had other clients and other counties that were providing FCRA benefits to their employees. To their
Wait a minute. Even because they didn't have to, but even though they didn't have to, these courageous employers chose to say, hey, sick correctional officer, stay home and we'll pay you.
Yeah.
Right? Wow.
It's
common sense, right?
And that was a fair way. It wasn't exempting correctional or law enforcement officers from FCRA benefits was not mandatory. It was
Yeah.
obviously voluntary.
Mhm.
And that was a big part of our argument in the courts. But here we had correctional officers that were using their accrued leave time, whether it was their sick time or their vacation time or some of their personal days, to cover time that they were missing. And we had, on behalf of the union, had been petitioning the county to provide these benefits, provide FCRA-like benefits to our correctional officers. We sent letters to the warden. We sent letters to the county commissioners, the elected officials, and at each turn we were denied. So we ended up amending our proposals to go into interest arbitration. We had general health and safety proposals. And so in addition to that, we made a proposal which not essentially, but exactly copied the benefits that the government had provided. It took what were the reasons in which you could receive these benefits from FCRA, and we put them into a benefit for correctional officers, and it would be applicable for the time in which FCRA was active. April 2nd.
So for those 9 months or 8 months or something.
Right. April to December of 2020. And the grievances piled up. We had a little over 40 individual, and a few of those were class action grievances. And the county agreed, and we agreed that we would present those issues to the panel. And so I was the advocate on behalf of the panel. Our colleague Stuart Davidson was the union's arbitrator. And one thing I will note is the arbitrator for the county, when we had these calls to try to figure these issues out in the beginning, had made a comment to me that he couldn't believe we were having the call to complain about our workers still being employed or still having a job or something like that. And it kind of set the tone, I think, for what was the start of our interest arbitration proceedings.
So he's an asshole, is what you're saying.
He's an asshole.
Yeah. Okay. Don't say his name. So no, it's just so stupid. So but one of the reasons it does happen to be a really well-structured court decision on the standards that the court would utilize in reviewing an interest arbitration award, and that's why we report the case out. But it's also interesting to talk about, not just because you were involved in it, but because it's a real example of, they didn't have to, right? Or a lot of employers didn't have to apply FCRA benefits to their public safety people. But then there's just because you don't have to doesn't mean that you shouldn't, right? And the contract was going to expire at the end of 2019. And so you're in bargaining while this is happening. I thought it was just a brilliant proposal. And I love LRIS listeners, know I love a common sense proposal. So the union says, okay, you're right. You don't have to provide it, but we want you to provide essentially the exact same thing via bargaining. Right. And, it's a great way to address something. And I think that that's why I'm a little surprised at the employer's response there, because the labor relations field is, it almost self-polices itself. You can get screwed, but not for too long, because the contract's going to be up and we're going to have our chance, to kind of come back against things. And that's why it was so interesting in this case that the employer just was like, no, we're not going to do it. Well, so I think the listeners probably know what the answer is. Well, so did the panel award the proposal?
So the panel awards the proposal. They provided 80 hours of paid leave, right? So it was FCRA-like. The county took that. They objected. The county arbitrator objected to that provision of the award, that one only, not the increase in the healthcare costs that they received, but they objected to having to pay correctional officers that used accrued leave over a finite period of time, essentially reimburse them for that leave. And their argument was that the panel had exceeded its authority and that provision of the award was contrary to the law, because they argued the majority of the panel, was forcing them to comply with FCRA, was
FCRA.
forcing them
To
to
violate FCRA.
yeah,
right?
to buy
You're
yes,
forcing us to do something that violates this federal law by providing FCRA benefits. They
exactly.
weren't, but the panel didn't order them to provide FCRA benefits, did it?
No, and that was the frustrating part. It was
Yeah.
that it was a proposal which mirrored FCRA, but this was a year after FCRA had expired. So part of our argument was the panel can't compel the county to comply with a law which has now expired. And it didn't. And ultimately, the county's arguments were the reason why they exempted a few of their emergency responders from FCRA was so that I could continue to provide the services of 911 responses and having adequate staff for the jail.
Yeah.
And so part of our argument at the court then was that they did achieve that. They had already achieved that by denying officers that ability to have FCRA benefits. There were some that had no choice. Either they were sick or their spouse was sick. They were really in a hard way that they had to end up using their accrued leave and take that time off. But there was no doubt officers who were sick that either didn't have the time, couldn't afford to use that time, showed up to work sick, and
That's
probably
crazy.
made others sick.
Probably.
Yeah, no doubt.
No killed people. I mean, it's nuts. So I mean, the court, what the court ultimately determined was that the panel's award essentially of retroactive sick leave was just that, right? And that sick leave is a mandatory subject of bargaining, and that the panel didn't exceed its authority in acting in that way. And it's a really well structured opinion. Kudos to you and kudos to the court. And my takeaway from that is really just to remember when you take these positions, and the unions do the same thing. Okay, there are bad unions or unions that take bad positions too. Like, do you think that we're just going to forget about that come bargaining time? And I'm sure, without getting into the rest of the award, but when an employer just takes a position that, is just so, stupid, and mean, I'm sure that the panel took that out on the employer in other ways too, right? I mean, I'm sure, that whether there's wages or other things like that, it's just, extraordinary that employers still do that. So good job, Tom.
Thank you. I appreciate that. It was one of, if not the best awards for this bargaining unit. Well deserved for the working conditions of these particular correctional officers as well. But you're right. I think the panel could see the context of the relationship here between the parties. And it doesn't always have to be like that. Management doesn't always have to try to stick it to the union. That's what occurred here. But we were happy that the courts saw through that, saw that this was essentially just additional paid benefits, which is what we've advocated for. And they provided those benefits to the members. And I will tell you that just this week, we have finalized the agreement for payment to those affected officers.
Oh, great.
A long time coming. We're now in 2024. The written consolidated agreement was just signed, and that was the 2019 to 2023 contract. And we're already heading towards interest arbitration on
the next contract. Oh, good Lord. God bless you. God bless those guys. All right, let's talk about there's another Pennsylvania case, right? Since you're Pennsylvania guys. So what's the other PA case we have this month?
The other Pennsylvania case is a firefighter's case.
Okay.
It comes from us. It comes to us from the city of Lancaster, Pennsylvania, which is as you know, and as I know, it's a beautiful part of southeastern Pennsylvania. My father went to school there and went to college there and near Lancaster, so we're very fond of it. And this is a story, or I guess this is a case between the union and the city, where the union president of the Local 319 of the International Association of Firefighters made a request for information. to the City of Lancaster's business administrator. And the initial request was for all correspondence between the fire chief and individual bargaining unit members from January of that year to the present, which was about 9 months of time that the union president was seeking correspondence between the fire chief and all roughly 75 members of the bargaining unit.
That's a lot.
That's a lot.
Yeah. Okay.
And the business administrator did not respond initially to the request. And so, as I'm sure we all do, or we advise our clients to do, they made a notation. And exactly 2 weeks later, they submitted an additional request asking if they would provide the information. And if not, they would be filing an unfair practice charge against the city. The business administrator ultimately did respond and denied the request as being overly broad, but did ask the union president to clarify their request by, I guess, identifying specifically the documents that they want. Instead of providing all correspondences, is there something specific that you're looking for?
So they asked for like every text, any utterance between the chief and any member of the bargaining unit for the entire year, provide us with a copy of. And the city said, well, can you, like, what do you, can you focus it a little bit? Right. Okay. I mean, I might've said the same thing. What was the response when they asked the union to focus it?
So they did not focus it. They went ahead and filed an unfair labor practice charge with the Pennsylvania Labor Relations Board. But then as that charge was being processed and after the union president spoke to their labor council, they did submit, I guess, a revised information request. And the revised information request essentially acknowledged that the first request may have been overbroad. Okay. And so the union president tells the business administrator that their lawyer advised them to narrow the request, and they wanted all correspondence between the fire chief and battalion chiefs from January of 21 until the present, which at that point was about a year now of correspondence between the chief, and there were 4 battalion chiefs. And the business administrator responds back also objecting to that request as being overly broad.
Okay. Did he say why or what? Like, because he initially asked for every communication between the chief and 75 people. I'm with you. But then they pare it down to communication between the chief and essentially like the bosses, which
right.
I'd like to know that too. But they said they thought that was too broad still too. Is that correct?
Right. The city, the business administrator, who no doubt at that point must have been speaking to their labor council, asked, what does this have to do? Can you tell me if this is with regard to a specific grievance? Is this regard to a specific bargaining proposal that you're seeking? There was back and forth, and the case, if you look it up, will show the email correspondences. And and
that's the case. Just so we reported on this case in the Public Safety Labor News last month. It's City of Lancaster versus PLRB, and you can find it in our June edition. Go ahead, Tom. Sorry about that.
No worry. The case itself, the correspondence is summarized, and as I'm reading this, Berks is popping up in my head. I'm thinking this is a similar relationship where the personalities are really strong here. And the email correspondence shows that. So there's back and forth between the union president and the business administrator about their need for this information. And I assume this is not assume, but I would say that this is probably germane to the case here, is that your rank of uniformed personnel in this department was chief, deputy chief. You had battalion chief, captain, lieutenant, and firefighter.
Yeah.
the position of deputy chief was vacant. And so you had the chief directly corresponding with battalion chiefs being still within the bargaining unit.
Okay.
The chief and the deputy chief were not. Even still, the union president didn't articulate the reason specifically why he needed that correspondence.
Okay. So there's back and forth. The union keeps asking, maybe narrowing the request. The city keeps saying, can you narrow it a little more? But did the city just ever flat out refuse and say, we're not going to give it to you?
No, and that proved to be very important in this case.
Yeah.
The city did not say, no, we're denying this request out of hand. They did say, can you provide us with more information about what you're seeking?
Mm-hmm.
And because of that, the courts, well, ultimately, this case did go before an ALJ and then appealed before the board, who both found it to be an unfair practice. They found that it cannot be seriously disputed that the request pertained to working conditions of bargaining unit members, and that the information must be deemed presumptively relevant under their case law, even though, as the court pointed out, there was nothing presumptively relevant about that request, since there was nothing specifically asked for. And so it did get reversed by the court because it was so broad that it was impossible to say whether it related to a mandatory subject of bargaining.
Yeah. Yeah. I had it, and so the union loses. I had a case, an arbitration years ago that we lost, and I'll never forget the first line of the arbitration award, and it was, collective bargaining is not a game of gotcha. And, that has stuck with me throughout my practice. And, I'm sure there may have been reasons why the union didn't identify the specific reason why it wanted what it wanted. I hope that there were, but look, an information request is going to be, it's presumptively reasonable, but if management is asking questions and looking like even facially that they're attempting to cooperate, then you can't just shut them down and expect a labor board to bail you out. And so it sounds like the management folks got some good advice there by not just refusing. But it's something to bear in mind. And, we'll talk about that in October in Vegas for bargaining, because information requests are a big part of, obviously of preparing for negotiations. And so 2 bargaining cases from Pennsylvania. All right, let's talk about some CO cases with some pretty interesting facts. Let's talk about the Colorado case first. I got one for you. So this one comes out of Colorado. And the caption is Young versus Colorado Department of Corrections. We reported this one out in the July newsletter, and so subscribers may have already seen this one. And this is the headline: mandatory DEI training did not create unlawful hostile work environment. You knew we were reporting this case out, right? And so what happens? We're in the jail system here, the Department of Corrections in Colorado. What do they do in and around 2020? Of course, in or around 2020, this happens, right? So we've got this correctional officer. His name's Joshua Young. He's a sergeant in the Colorado Department of Corrections. And in 2020, the department implemented a mandatory diversity, equity, and inclusion initiative, the DEI initiative, in the jails. And they had mandatory training for all their employees. Wasn't voluntary. Everybody had to go through it. And basically the training was you sat at a computer module. You sat at some, all the CEOs didn't have their own computer, right? But you had to sit at a terminal, tap the space bar, and go through a 30-minute, or whatever, review of DEI principles. And, it was a pain in the ass, right, for most of the employees. And aside from what their views are, no one likes to sit through those types of training things, but people did it. Okay. Young really didn't like it. Okay. And, some of the things that he identified in this suit were, there was a glossary of terms stating that all whites are racist, that white people created the concept of race to justify the oppression of people of color, and that whiteness and white supremacy affect all people of color within a U.S. context, close quote. Okay. They're also, he complained that the glossary states that white people are triggered by feelings of guilt and fear when confronted with information about racial inequality and injustice, a phenomenon labeled as white fragility. Like this guy, Young, who I'm guessing is white, it just drives him nuts, right? So rather than just maybe if he thinks it's silly or it's a little too PC or woke, he's like, I cannot do this, and I think that this DEI stuff promotes racism because it essentially says that everybody white is racist, at least according to Young. I think everybody's probably racist, I would imagine. But so Young submits a formal complaint to the DOC saying, right, this is an EEO complaint. He submits to them saying, you have created a hostile work environment for me by forcing me as a condition of employment to sit through this DEI training. Okay. And they process the complaint. Before they can get to the end of the investigation, he quits. And then he turns around and he sues him. He files a Title VII lawsuit. So he sues him in federal court, alleging that he was discriminated against on the basis of his race. And the department moved to dismiss the lawsuit, which was successful. And then it went up to the 10th Circuit on appeal.
I was going to say, Rick, if I could just interject here.
Yeah.
Every correctional officer in America works in a hostile work environment.
Yes.
But legally speaking, not everything is a hostile work environment. And that is what was the issue presented before the 10th Circuit here. Yeah,
right. I mean, harassment, right? There's harassment, and then there's unlawful harassment. If you harass somebody, you bother them, right? I mean, everybody bothers me, but I can't go around suing everybody saying that they're harassing me. And, the union reps, more so than the management people, actually, probably who are listening to this, you get hit with this all the time. I'm being harassed. Somebody's harassing me. And the question isn't whether they're harassing you or bothering you. The question is it unlawful or not? And yeah, so-and-so is creating a hostile work environment. Yeah, I would go further, Tom. I'd say every work environment is a hostile work environment, depending on which day of the week it is, right? People work from home, their work environment's a hostile work environment. But he alleged, this was a hostile work environment, and there is a test for that. And so the 10th Circuit Court of Appeals, in weighing whether the case should go forward, basically told us what a plaintiff would have to establish in a case like that. And so in order to establish a true hostile work environment race discrimination claim, what a plaintiff would have to do is establish, one, that they're a member of a protected class, two, that they were subject to unwelcome harassment, three, that the harassment was due to their race, and four, that the harassment was, this is important, so severe or pervasive that it altered a term, condition, or privilege of employment and created an abusive relationship. Okay, now, so the court said 1 and 3, right, are easy, right? So he's a white guy, member of a protected class, and he was certainly the nature of the DEI training certainly was something that affected him as a white man. It was based on his race. So the court said, we got you. Tier 1 and I'm sorry, prong 1 and prong 3 are fine. Now, did this constitute unwelcome harassment? The 10th Circuit said, well, you know what? It might actually, if we really play these things out to their extremes. And I think that that's what makes some of these DEI programs they're kind of low fruit. They are really easy to pick on sometimes because they can lay out, a pretty extreme view of things, which can tend to overshadow a lot of the positive, messaging, within those programs, which I think the gist is like, hey, try to be, everybody try to treat everybody fairly. But the court said, well, if you take this rhetoric to its extreme, it could in fact create or constitute unwelcome harassment if you force some white worker to sit through a program that tells them that they're racist for an hour. So the court said, oh, maybe I'm with you on that. But the fourth prong, the court said, you're not nowhere near there. This was not a hostile work environment. There was not severe, or pervasive discrimination, in this particular workplace, right? And what does the court say we look at? We look at the frequency of the conduct. Is it physically threatening, or, is somebody saying something inappropriate? Does it interfere with your work performance? These are all the types of things that you might want to see. And, how did it affect your job? And in this case, it didn't affect this officer's job at all. He just said that he couldn't take it anymore, and he says he was forced to resign, but there's no indication that he had no other choice, and he had already satisfied the criteria. And so it's a pretty easy one for the court. The 10th Circuit just restated the standard and said, look, just because you think a work environment's hostile, it's not. And just because you have to sit through a training that you think is dumb, doesn't mean you get to sue your employer. If that were the case, then every employee would get to sue their employer constantly, because most training, as we know it, except LRIS training, is dumb. Okay, so that's the Colorado case. Now we have another interesting CO case, Tom, out of New Jersey. What one is that?
That would be the Stephen Allen Gloucester County Sheriff's Office. He was a sheriff's officer in Gloucester City, not far from where I live, where back in December of 2016, this was a 2024 case. This was recently issued.
Yep. Yeah, this is actually in our next newsletter.
Okay, great. So back in 2016, December of 2016, Officer Allen was assaulted by another officer, and he sustained pretty significant injuries, and that required surgery. He was on leave for over 6 months, recovering from his injuries and the surgeries subsequent to those injuries. The other officer that inflicted these injuries on him, that was also the one that assaulted him, he resigned in April of 2017, which was a few months after this incident, rather than face what was going to be likely discharge or severe discipline. However, the department rehires the assailant, Officer Allen's assailant, in October of 2019. So less than 2 years later, right? Or just a little over, excuse me, a little over 2 years later, they rehire this officer. No reason given as to why they did that.
He assaults another officer, they're going to fire him, and he resigns in lieu of termination. And then 2 years later, they're like, yeah, you know what? Come on back. And so we started out the podcast talking about recruiting retention challenges, didn't we? Right. And so this is what happens, right? It's hard to find people. And this is before inflation went nuts and before COVID. They invite this other officer to come back to work. All right. I'm sure Officer One, who's the victim of the crime here, is thrilled with that. So how does the employer say they're going to deal with this situation?
Yeah, the case doesn't give the story about maybe how the union helped with this issue, but essentially what it appears as though the city comes to Officer Allen, they say, you know what, don't worry, he's going to be in a different unit and you won't have to work with him. You'll hardly see him at all. They did put him in another unit, but he did see him about twice a month in the courthouse. He did have to see him when they were to be recertified for firearms training. He would see him on the range. And occasionally, the Officer Allen was included in group emails that were sent directly from his assailant.
Remember when we were just talking about a hostile work environment and whether something is or isn't? This could be one, right? This could be one.
It was so much so that Officer Allen then visits his doctor because he's experiencing so much anxiety from the rehire of his assailant that he gets put on anti-anxiety medication. He does explain his concerns to his supervisors, but he doesn't file any formal written complaints. Outside of making general statements to his supervisors. Officer Allen then says that as a result of the stress, his post-traumatic stress disorder, that he began to self-medicate himself through the use of marijuana on a daily basis.
And this
he started that in July of 20.
Okay, that's a little early in New Jersey, right?
Little too
Recreational
early.
marijuana had had not yet come to pass. So he
And
self-medicates marijuana daily, and I know what's going to happen next. What happens next?
he gets randomly drug tested,
Of course he does. Yep.
of
Yep.
course.
Yeah.
And he has a positive result for marijuana. And he knew, as well as anyone that worked in this department, knew that it violated several policies that covered his employment. And the penalty for that was termination.
Mhm.
And he was terminated as a result of violating uh, those policies. And he would admit that. He would admit that he understood that he had violated those policies, um, but didn't, and that he did not submit any additional written complaints to the department or attempt to uh, speak to his doctor and adjust his anti-anxiety medication before he ultimately decided to self-medicate with marijuana.
Uh-huh.
The department terminated him again, and he appealed that to the New Jersey Civil Service Commission, that's known as PERC. And a hearing was held, and he argued at this hearing that the department essentially drove him to his marijuana use by rehiring his assailant and ignoring his occasional verbal complaints, sporadic as they may have been, to his supervisors. At that hearing, he introduced testimony from an expert psychiatrist who had evaluated and treated, hundreds or thousands of law enforcement officers, and testified that Officer Allen's use of marijuana was a reasonable response to PTSD. And because he had had mild traumatic brain injury and major depression that was caused by his attack. And this is why you have to be so careful when putting on witnesses. On cross-examination, the doctor conceded that he was unaware that Officer Allen had actually been treated for his anxiety prior to resorting to marijuana, and that he had been on anti-anxiety medication. And he also admitted on cross-examination that he himself, this doctor, had never prescribed marijuana to treat PTSD or any other condition, even though he testified to its beneficial properties.
Yeah.
So the PERC, the hearing officer, upheld the termination, and Officer Allen, undeterred, appealed that to the New Jersey Superior Court. And the court was limited. Again, the standards of review are pretty are pretty standard throughout the country, and so they were limited on what they could look at. Right, it's not a new hearing; they couldn't rehear testimony, and they could only overturn the lower decision if they found it to be arbitrary or capricious. In this case, they held that the decision was reasonable, and they easily upheld the termination, stating that Allen has provided us no reason to reverse the findings of the ALJ adopted by the Civil Service Commission. Allen admits to his illegal use of marijuana, and the ALJ, who had the opportunity to hear the testimony of the witness and to evaluate their credibility, found Allen's testimony as to why he did so as, quote, rehearsed, self-serving, and ultimately not credible. The court also found that there was no evidence that Allen had ever complained to his supervisors about the rehiring of the assailant, and his own admission that the two of them virtually had no contact after the co-worker's return proved to be some pretty damning facts. And so they were not persuaded by the expert's testimony that he had suffered PTSD, and so they upheld the termination because, when you're dealing with police officers or law enforcement officers that are public employees, if the infraction is so serious that it goes to the heart of their functions, of what they're hired to do, that if you violate that, especially here, when marijuana could impair his decision making, it was considered conduct unbecoming, and termination was determined to be the most appropriate penalty.
Yeah. Yeah. So the officer loses. It sounds like the right decision. There's two ways of looking at the case. It's one is like, oh, the dog ate my homework. I test hot on the pot on a random test, and I come up with some excuse that, oh, you created a rotten environment and that's why I had to self-medicate. Yeah. And there's also, the looking at it from the officer's point of view. Now he was assaulted, right? Arguably the victim of a crime, right, in the facility, and then he has to work with his assaulter, which it seems insane to me. And we know PTS is no joke in public safety, and there probably was maybe some PTS as a result of this. We do know that marijuana can be an effective treatment for PTS. So if there's enough there that you could put together, I think a strong claim. But the problem here, and I think for listeners, and when union folks, especially when you have a member that has an issue like this, some type of harassment issue, some type of EEO issue, the first advice should be, hey, management has a policy. You need to file a complaint through the policy. You have to file a charge. Keep us posted, because this guy didn't do that. And he waited, and maybe he made some remarks, and and maybe he complained, and maybe he didn't. But you really got to get that claim in, that charge in, because that would have helped this case a lot. If you then filed a charge and said, wait a minute, I'm dealing with severe anxiety because of blank, and that's documented. And let's say they rehired this guy because he's the sheriff's brother-in-law. I don't know what was going on here. That happens. And then the officer tests hot. I think the employer's going to think twice, before taking any action. So, it's maybe just somebody making some stuff up, and the hearing examiner certainly didn't think he was telling the truth. But there's enough going on in here that I think that, there could have been ways to maybe address this differently. And if the recruiting situation is so rough that they have to hire back somebody who beat one of his coworkers up, you think that the employer would want to, do everything they can to prevent people from leaving. So interesting case, some interesting, arguments raised by employees, both unsuccessful, but that's okay. Okay. Well, we had a long one. It was a good conversation, Tom. I appreciate your time. Those are the cases. If you want to hear Tom talk more about discipline cases, come on out and see us in Vegas in November. If you want to hear Will and Jonathan Downs and myself talk about collective bargaining for a few days in Las Vegas in October, please come on out and see us there. That's it. Hope everyone has a great month, and we'll talk to you in September.